Before I begin, a trigger warning on this particular video for details of rape and for details of the death sentence. It can be upsetting to a few people. So today what has happened is the Kolkata court has given its verdict in the RG Kar rape and murder case. Remember, in the hospital there was that young doctor who was on duty, who was attacked while she was resting in one of the conference rooms, and she was found murdered the next morning. And then consequently details emerged that she had been raped as well. Now, the main accused is Sanjay Roy, who has been given life in prison as a term. And the additional district and sessions judge had actually, when he'd given out the sentence, basically said that this does not fall into the category of rarest of rare. And that is why he has decided not to impose the death penalty in this particular case. Now, the judge's name is Anirban Das. He's further said, though, and this raised an eyebrow, since the victim died while on duty in hospital, the state government has to give compensation to the family, 10 lakh rupees for the death and 7 lakh rupees for the rape. And that was odd and worrying. But the real reaction has come to the fact that it is a life sentence and not a death sentence. And the justification is this does not qualify as rarest of rare. Now, the parents of the young doctor have responded to this, saying that they are not satisfied with the sentencing, that they will move to a higher court. And the father of that young doctor has said that they do not want any compensation. Now, from here, from the Sessions Court, the case could go to the High Court, and from the High Court, it will go to the Supreme Court. Now, obviously, there's been a lot of political reactions, as they are in cases like this. West Bengal Chief Minister Mamata Banerjee has also said that we demanded the death sentence. The court has given life. So the case was forcibly taken away from us. Had it been with Kolkata police, we would have ensured a death sentence. BJP's spokespeople, specifically Amit Malviya, has responded saying, life imprisonment for the accused is a travesty of justice. The verdict must be appealed. So it does seem like in general everybody agrees on a re-appeal of this case and the fact that people are asking for the death sentence in this particular case. But what I want to bring to you in this video is an examination of the two sides of the argument. So when we talk about rarest of rare, within Indian jurisprudence, what did we arrive at? Like, how have the courts come up with this rarest of rare? What does it mean? And how does it apply? And what the various arguments are on both sides, so that you can make up your own mind as this case goes forward. So in the 1973 Criminal Code, it brought about two important changes in our law. And I'll start with 73 because I don't want to go all the way back to the 1800s. So let's start with 73. Now, it actually brought in a section 3543, which basically said that life sentence should be the norm and death penalty should be a very exceptional punishment, and it should not be a norm for everyone. It also said that judges should lay down special reasons wherever they bring in that death sentence. That basically, you should be giving the life sentence, and only in exceptional cases you should give the death sentence. And in those cases also you have to explain as a judge why you have chosen the death sentence. That was 1973, which is why you normally have a trial in which the accused is pronounced either guilty or innocent. And if guilty, there is a separate hearing in which the accused themselves can have a say and they can put their case forward, and then the judge gives a sentencing. So where we are at this case is sentencing at the lower court. Now, the BNS, which is the changed criminal code, actually has maintained both of these things. So if we now take a look at the idea of rarest of rare, where has it come from? And the Indian jurisprudence or the basically our judicial philosophy, our justice philosophy when it comes to the death sentence. We have to examine one particular case. It was called Bachchan Singh versus State of Punjab, 1980. Now, in this case, there was a 5-judge bench of the Supreme Court, and the constitutional validity of the death sentence was brought before the Supreme Court. So they had to decide whether or not the death sentence is constitutionally valid and should be given in India. What happened in that case is that 4 judges decided yes. 1 judge said no. And that sole dissenter was Justice Bhagwati. Now, and I'll tell you what the 4 judges said, but the one dissenter is very interesting here because it gives us both sides of this argument. So what Justice Bhagwati did, and he took a really long time, he asked for time, he took a really long time to write out his dissent. But he fundamentally broke it down into 3 reasons why he believed that the death penalty was, according to him, cruel and inhuman and disproportionate as a punishment to be handed out by the courts. Now, his first argument was that unlike other forms of punishment, the death sentence is irrevocable. You cannot reverse it if you've decided that this was a wrong judgment. Once it's done, it's done. And he basically argued that there is an inherent fallibility in Indian courts, that courts make mistakes, that sometimes the investigation is poor, sometimes the testimony is false, sometimes the prosecution is wrong, sometimes, of course, evidence is lost. And so there is a possibility, even if there is a slight possibility, the possibility of executing an innocent person cannot be ignored. That was his first argument. Secondly, he argued that the entire process of being sentenced to death and then waiting for it to happen is just intense mental and physical suffering, and that should not be okay. And lastly, he argued that, that fundamentally, at least in India's law, the Indian law is designed with the idea of reformation. So people are put in jail not as fundamentally punishment for what they have done, but to reform them and put them back into society. So even if, for example, someone is given the life sentence, depending on the nature of that sentencing, with good behavior and, they can actually reduce that sentence and actually be rehabilitated into society. That's the philosophy of it. The death sentence doesn't believe in that philosophy. Now, these 3 were one side of the argument. That was Justice Bhagwati's argument. The other 4 judges, though, agreed unanimously between the 4 of them that the death sentence should form part of our jurisprudence, right? So in majority 4:1, constitutionally in India, the death penalty was upheld by the Supreme Court, and a principle was laid down in this particular case that the death penalty must be used only for the rarest of rare cases. But in this case, they did not actually specify the scope of what rarest of rare is. So how does it actually become rarest of rare? That was not actually written down, right? So it was then what you have now is left to the judges to decide, is this rarest or rare or not? Now, if we move forward, and this was 1980, now in 2008, there was another case called Prajit Kumar Singh versus State of Bihar. And this was also before the Supreme Court. And the court ruled on what exactly would constitute rarest of rare in this case. The court held that the death sentence would be awarded only if a murder is committed in an extremely brutal, an extremely grotesque, diabolical, revolting, dastardly manner, so as to arouse intense and extreme indignation of the community. So if you think back, and the death sentence was used in that case, you'll remember the Nirbhaya case, which was all of these things. These people got together and they decided, they planned, they went out with the intention, the nature in which that young woman was tortured and injured, and the grotesque and brutal manner in which they hurt her, and also the fact that it aroused deep disgust and emotion in the larger community. It qualified as rarest of rare. So fundamentally, one would argue, or legal experts argue, that rarest of rare, like any other subject, has a certain amount of criticism, that has come onto the various interpretations, including what Justice Bhagwati has put forward, which a lot of people are still sort of examining and saying, okay, what Justice Bhagwati said still holds. But one of the arguments that's come forward is that rarest of rare being subjective to the kind of judge and what that judge's personal preferences are, could actually then be in violation of the fundamental right of equality, Article 14 and Article 21, and that then is against a fundamental right and so non-constitutional. So these are the various arguments that are coming forward. Now, what has been happening with the death penalty in India? Let's take a look at the numbers. So there's been something called a Death Penalty India report that came out in 2016 by Project 39A, and this is an organization that does work specifically to do with the death penalty. Now, according to this research, it said that in the 15 years between the year 2000 and 2015, there were 1,486 death penalties that were handed out, and less than 5%, so only 73 of those prisoners, only in those cases was the penalty upheld. The sentences of 970 prisoners, so 65%, were commuted. So basically, they were changed, and 30% of those on death row were acquitted by the higher courts, were actually set free by the higher courts. So does this in fact show that there are huge problems in our legal system, and that in many cases there are innocent people who are falsely found, who are falsely accused, and then in the lower courts are found guilty? And that is the problem that casts a shadow under which we are sitting today. So the argument is not that this individual needs to be shown any clemency. The argument is that the system itself is flawed. And because we function in such a flawed system, it throws a very long shadow on cases like this as well. And it has created this complex structure in which it's not really clear when rarest of rare applies and when it doesn't. Let's take a look very quickly at the Nirbhaya case, right? Because again, trigger warning, because you remember how terrible it was. There was a death sentence that was given to 4 of those convicts. The 5th one was a juvenile, and that then led to the review of the juvenile cases and the law about juveniles in India. That's a separate story. But for the 4 people, there was a death sentence that was handed out because it was a gang rape, which means it was premeditated, it was planned, it was a murder, it was brutal, it was barbaric, it was diabolical, and it shook the conscience of humanity. And it was argued that they deserve extreme punishment. Now, the other flip side, of course, about shaking the conscience and deriving or drawing an uproar from community is that there's also a lot of media outrage, and judges need to protect themselves from simply reacting to the media or simply reacting to the outrage and actually looking at the case themselves. After that, there were a couple of other cases that I do want to very quickly take you through. So obviously, there was the Nirbhaya case in 2017. There was the Dhananjay Chatterjee versus State of West Bengal, 1994. Death penalty was upheld for the rape and murder of a schoolgirl because it was a very heinous act. State of Rajasthan versus Shambhu. This is 2002. Death penalty was awarded for the rape of a child. Court highlighted the vulnerability of the victim. So like I said, it brings us to the judicial responsibility. The judge has a certain responsibility because rarest of rare now sits purely subjectively on his plate or her plate. It depends on the judge and how they feel. So they have to make sure they're not reacting to public outcry, that all mitigating factors have been thoroughly considered, and decision aligns with the constitutional principles under right to life and of course right to equality under the Constitution. There are many, like I said, many problems and arguments against the death penalty, problems with the system at all. I think one of the things that would simplify what we are feeling today and what we are going through today, where you feel that yes, there is justice because the person was caught, he was brought before a court, the evidence was presented, he's been found guilty. Sentencing point, you're thinking, is this not enough? Would it be better if there was actually a standardized guideline laid down by the Supreme Court on what qualifies as rarest of rare? And then this sort of feeling that we're having that I'm not satisfied will go away because we'll know what the borders of our law says and whether or not this falls into that border, right? The fact that also when the death penalty is given, it takes years and years and years, and then rounds and rounds of clemency, which happens. They appeal to. They're allowed many appeals, obviously, because if you have given out a wrong sentence, we can't reverse it. But it just goes on for years, and there's this argument that that kind of torture, like I said, is also not fair. So, is there a way to streamline that process and make it more efficient? And of course, The biggest problem, and we should acknowledge this problem because that's the world that we live in, is the politics around it. Especially we've seen in this case, the politics between Mamata Banerjee and her party that runs West Bengal and the key opposition of that state, which is the BJP. This particular case, both of these sides sort of came down very heavily on. And we've seen this happen in the past, where as soon as a case like this happens, politicians will start baying for blood, right? They rouse the mob and they say, we want a death penalty. We want it immediately. There have been some cases in which it's been demanded that these people be hanged in public. It's not part of our law. It cannot happen like that. But it's basically pitchforking of the villagers, right? You're calling the mob to bay for blood, and that's not how jurisprudence, that's not how the legal system needs to function. The legal system has to be cold and calculated and consider all the evidences so we don't make a mistake. Because if we do make mistakes, it weakens the whole system, especially in cases where justice is needed, in this case. And that's the problem. Also, politicians will find it very easy to demand death sentence because they have not done all of the work to improve safety on the ground. There are dark patches in our cities. Petty crime is allowed unnoticed. Our police is not adequately staffed. When people go into police stations and complain about stalking, when they complain about harassment on the road, when they complain about, all of these smaller crimes, they are ignored because the police is insensitive or they're just overworked. And that then turns into rape, and we don't react until it becomes a really heinous crime. And it's true, we have a problem with rape in this country because the numbers are astounding. So it'll take a lot of work on behalf of our politicians and our police system to bring down the number of cases. Now, that is work that nobody wants to do. Whereas if you go ahead and you say death sentence, you seem like you're being very hard on rape, but you're not, because you're not willing to do the groundwork on the ground to improve safety for women. And for as long as you're not willing to do that, just standing on your stage and demanding death sentence is simply, it's theatrics, right? Because you're not doing the actual work on the ground. So every time a politician says death sentence, we should remember that they're doing it to cover up the fact that the actual truth on the ground is not what it should be. There needs to be better safety for all women on the ground. Women who are working night shifts, women who are working day shifts, who are staying late in the library, who are working as nurses and doctors, those who are working as lawyers, whoever it is, right? We need to create a system where women feel safer and not use heinous crimes and death penalty to throw a shroud over it and make yourself seem good. So I think that at this point, we're feeling a little like the system has not served us well. And this is a symptom of a much larger problem. It is a symptom of the fact that we're not able to efficiently execute justice in thousands and lakhs of cases across the country. And that is why our system is weak. And that is why in this particular case, we're feeling that we didn't have enough justice. Leave me a comment in the comment section on where you stand on this. And I know it's upsetting, but forward from that, do you believe that as India we should have the death sentence? Because I know people have very different opinions about this. And if we do, how do we create a system where we are not falsely, sentencing people who are innocent, and we create a system that is clearer and more efficient? I want to know what you think.